In this video, we're going to talk a little bit more about likelihood of confusion when we're talking about the possibility of confusion at times other than source confusion at the point of sale. And here I think it's worth beginning by returning to the subject of how open the text of the Lanham Act potentially is when it comes to these issues. So the likelihood of confusion standard, likelihood. How likely? Who? How many? How deeply is the confusion experienced by those who are likely to feel it? Confusion. What kind of confusion? Is it material confusion? Is it necessary confusion only of source? Is it also of matters concerning sponsorship? How far beyond sponsorship does that go to simple affiliation or approval? Could approval extend to the point of permission? When is this confusion felt? Is it at the point of sale? Is it before the point of sale and still actionable, even though the uncertainty is resolved prior to purchase? Could it extend to potential confusion that arises after the point of sale by someone other than the actual purchaser? How do we measure all of this? What is the baseline of comparison? What is our ideal state of consumers who are at an acceptable level of likelihood of confusion? And does the kind of confusion that is being alleged affect that analysis? All of these are substantive questions that courts have to resolve before we can deal with the empirical uncertainties that naturally attend trademark infringement suits. And then we can ask about limits. And of course, the next part of the course, we're going to deal more with limits to the likelihood of confusion cause of action. But for now, let's focus our discussion on infringement claims that are not simply about source confusion at the point of sale. And so let's begin by talking about what people often refer to as the merchandising right. The ability of trademark holders to use their trademark rights to control markets in which the marks are used as a feature in product merchandise, promotional goods, things like baseball caps, things like jerseys, things like college sweatshirts, and the like. And the foundational case of the merchandising right is Boston Professional Hockey Association versus Dallas Cap and Emblem Manufacturing Incorporated. And it's maybe not fair to point to this case because it's not really cited quite so often for some of its very broad propositions, but it kind of sets the tone for cases involving the merchandising of trademarks. And there, the basis of the confusion finding on the part of the court is strained from the get-go because there's an acknowledgement that buyers are not deceived. And of course, this makes sense. When you want to buy a Boston Red Sox baseball cap, you don't do it because you think the Boston Red Sox make a good baseball cap. You don't do it because you think that the Boston Red Sox have made the baseball cap. Rather, you happen to want a baseball cap that has the Boston Red Sox B on it. And there's any number of reasons why you might do so. Most notably, of course, if you're a fan of the team. And so it's not that the court is too stupid to get this point. It gets this very point, but says that nonetheless, the confusion requirement is met, quote, by the fact that defendant duplicated the protected trademarks and sold them to the public, knowing that the public would identify them as being the team's trademarks. And this is a little bit odd from the perspective of how we've been analyzing trademark infringement, how we've been analyzing likelihood of confusion to this point. And the court indeed acknowledges that its ruling tilts trademark law from the purpose of protecting the public to the protection of business interests. So why do a thing that is so seemingly out of step with the trademark tradition? And the court really here relies a lot on policy. And so they make 3 points. Number one, that the value of the emblems derives from the plaintiff's efforts. And so this really kind of gets at this free riding argument, this idea that the defendants are somehow reaping where they have not sown, and that the party that deserves the profits that come from the sale of merchandise are the trademark holders. And of course, there's a lot to quibble with here. In the cases of marks that are popular with team fans, the activity of fans is part of the value as much as anything the trademark holder may have done. Nonetheless, there's this very strong intuition, and it's held, of course, not only by the courts, it's held by people who are surveyed about this, it's held by juries. It's a common intuition. And so from perhaps a democracy perspective, this is not as offensive a ruling as it is from a traditional trademark policy perspective, but there's a strong sense that the trademark holder ought to own this market. And insofar as we have human intuitions at work, it's not surprising that the law fits human intuitions, even if the law has to be contorted a little bit to the task. So that's really the primary policy reason. And the others, I think, are kind of make work. They say, well, the defendant had sought the right to sell them, but, so what? If the defendant has the right, it has the right. If it doesn't, it doesn't. That's the issue that's at stake at the case. And the merchandising of logos is an accepted business practice. Well, all the more so if a court is going to recognize trademark rights as protecting this business practice. And this kind of introduces this problem that's particular to the merchandising context of something of a circularity problem. This idea that consumers think that approval or permission is required on the part of the trademark holder. But of course, this is so much more likely if the courts will hold that trademark rights protect the trademark holder in withholding this kind of permission in the first place, right? And so the reason why people think sponsorship is required is because the only merchandise marks you see out there are the ones that are sponsored or approved by the trademark holders. And the reason why you don't see any others is because courts will go after anyone who does release a merchandise product without the consent of the trademark holder. And then when push comes to shove in liability litigation, the courts say, well, yes, because there's a likelihood of confusion, because consumers think that permission is required. Well, why? Because courts keep arriving at this conclusion, and that's the circularity loop. And in addition, the defendant made a functionality argument and, saying that, look, this is something that is a competitive necessity insofar as people want the merchandise products of these specific teams. And this is the very argument we've discussed before that was rejected by the Ninth Circuit in the automotive gold case. And so let's talk about the automotive gold case, because we've talked about it previously in the context of the rejection of the functionality argument on the part of the defendants. And now we can talk a little bit about how the court goes about finding a likelihood of confusion and ruling in favor of the plaintiffs. And so what is the likelihood of confusion at issue here? And I want to talk about automotive gold in this context instead of Boston professional hockey, because automotive gold is more in keeping with sort of normal trademark talk and not this sort of well, they recognize this mark as having come from a particular trademark holder, which is kind of, doesn't make much sense in the context of whether or not there's a likelihood of confusion as in a manner that is prescribed by the Lanham Act. So in automotive gold, the court says, likelihood of confusion, quote, exists when customers viewing a mark would probably assume that the product or service it represents is associated with a source of a different product or service identified by a similar mark. So we have this idea that likelihood of confusion as to an association is good enough for trademark infringement, and this should echo some of what we talked about in an earlier lecture in the Maker's Mark case. But it raises an immediate significant problem. What exactly does association mean? What can it mean? Now, of course, source would be a form of association, and no one quibbles with the idea that that is something that has always been prescribable by trademark law. Perhaps sponsorship, too, the idea that somebody is standing behind a product. Fair enough. But Section 43A in the Lanham Act refers not just to source, not just to sponsorship, but also to approval. And this is where things get really murky indeed and potentially quite broad when it comes to trademark holder rights. Because what exactly does approval mean? Now, perhaps it means something along the lines of, my trademark means that I stand behind this product. I endorse this product. And here you can tell some consumer protection stories about protecting consumers from this kind of confusion, insofar as a consumer may rely on a representation of standing behind a product as being a reason to buy it. But approval could go further and say something along the lines of, my trademark means I gave permission for its use. And that is potentially quite a broad scope of trademark rights and potentially reaches into a lot of conduct that may not be material to consumer purchase decisions and may also start to run into First Amendment rights on the part of trademark defendants. And we'll see this issue particularly acutely when we get into the context of expressive defendant uses of trademarks in a later lecture in a couple of weeks' time. Given that we're talking about association and for all its potential breadth, we can ask, do the factors help in sussing out whether or not there's a likelihood of confusion here of which we are particularly worried? And so how does the court go about this? They talk about the strength of the mark, and just the fact that Volkswagen and Audi have strong marks is enough to weigh this factor in favor of the mark holders. And, again, is this just a universal thumb on the scale that exists every time the holder of a strong trademark bringing litigation? Query how much this is just setting up a basic rule that says this kind of merchandising market, this kind of promotional goods market simply belongs to the trademark holder. What about proximity? Well, the same end buyers, but again, it's a different kind of product. The sellers of cars are not necessarily competing with the sellers of accessories that are used with those cars. Nonetheless, the court says, well, it's the same end buyers, so the markets are very close. Consumer care, these are cheap goods, and therefore there's a low degree of consumer care. And then here we see one of those cases where the intent factor plays a mischievous role. Because Otto Gold, the defendant, says, look, we're just filling a market niche. And the court says, yeah, that sounds a little bit too much like your functionality defense, and we've already ruled against that. And the fact that you're counterfeiting the mark, that tilts this factor in favor of the mark holders. But to call it counterfeiting is begging the question. I mean, the whole issue in this case is whether the defendants are doing something wrongful, and the court's invocation of counterfeiting language kind of gives away the game. That the court thinks that this is free riding is bad, and that's not good, and therefore the defendants have to lose, and the factors sort of start to line up in accord with that conclusion. Think about the way the court treats actual confusion. There is none, and indeed the defendants use disclaimers in their products. But the court says, this is neutral, because even though there's no confusion on the part of the purchasers, there's a problem potentially as to post-purchase confusion. And we start to introduce this idea of likelihood of confusion, not just at the point of sale, but later on, at some later point. Someone looks at your, Volkswagen keychain and thinks like, oh, maybe Volkswagen is behind that. So what? The court doesn't really explain why so what. But we get this idea that we've talked about before, that certain causes of action that are based on things other than source confusion at the point of sale, even though they are less problematic for consumers in the sense of causing harm to consumers, are in fact easier to prove. And that's a tricky thing about the way the likelihood of confusion multifactor test is deployed in these settings. And the court again dismisses the idea that disclaimers are able to solve the problem. And so what's really going on in these cases? I mean, we have this strong intuition, and again, you see it in surveys of consumers in general. So it's not just judges who believe this, that the rights to a trademark, or at the very least a strong trademark that has a significant amount of acquired distinctiveness, a significant amount of popularity with the consuming public, the ownership of that trademark ought to include an exclusive right to manufacture promotional goods and to control the markets for merchandise and promotional goods that display that trademark. I don't like it. I think that's bad for consumers because it creates an artificial monopoly and therefore allows trademark holders to extract monopoly rents in the marketplace. Doesn't matter what I think. There seems to be a strong intuition that this is the way things ought to be. Given that, query if we couldn't simplify cases involving this right without getting the multi-factor test involved. Because I think one of the things that happens here that's a little bit tricky and a little bit dangerous to trademark litigation in general is the flexibility with which the court applies these factors and kind of waves its hand about factors that would normally seem to favor the trademark defendant. And because we're in a realm where the court is so convinced that the trademark plaintiff has got to prevail, there's some distortion going on in the application of the multi-factor test. And so query if we couldn't think of another way to handle this kind of allocation of rights to trademark holders without messing with a test that isn't the clearest to begin with, but making an already imperfect test even more obscure.